So, you've read the chapter and taken some notes. Now, let's talk about corporate social responsibility and business ethics. This is a review of Module 1.2. So, I have a bit of a confession to make. These review videos and all of my lecture slides are merely my notes on the course materials. My notes are distinct to me, as your notes should be distinct to you. Some of the abbreviations used in my notes will be standard to the legal field. Others are just standard to me. After a few videos, you will start to get the hang of matching course content with the abbreviations. But until then, I have placed a few frequently used abbreviations here. Students are encouraged to use these or any other abbreviations in their notes as a method of shorthand. You can use mine or you can make up your own. But either way, when responding to written assignments or discussions or short answers, students should refrain from using such informal abbreviations. I mean, you wouldn't use these kinds of abbreviations in any of your English writing courses when writing an essay maybe, so why should you get away with it here? And that's a rhetorical question, not meant for you to make up any reasons why you should be able to get away with it here. Okay, let's get into it. After reading this chapter, we should understand the following: what ethics is and be able to explain the importance of good ethics for business people and business organizations. We should understand the principal philosophies of ethics, including interest-based ethical theories, duty-based ethical theories, rights-based ethical theories, and virtue-based ethical theories. We should be able to distinguish between ethical merits of various choices by using an ethical decision model. We should be able to explain the difference between shareholder and stakeholder models of ethical corporate governance. And we should be able to explain why it is difficult to establish and maintain an ethical corporate culture in a business organization. Overall, the goal of this chapter is to introduce you to the differences between legal and ethical compliance and ethical excellence by taking a closer look at philosophical perspectives that apply to businesses, business people, and the role of business organizations in society. Now, let's start with the first of these objectives and define ethics and explain the importance of good ethics for business people and business organizations. Let's take a look at how law differs from ethics and why a good reputation may be more important than legal compliance. How do we distinguish between ethical or moral or even legal responsibilities of individuals and also those we ascribe to businesses or even nations? While ethics, morals, and law are similar and they may overlap, they are distinguishable from each other. What is legal is not necessarily ethical. What is ethical is not necessarily legal. And what is immoral may neither be unethical nor illegal. Now let's take a look at what ethics, morals, and law actually means. Ethics may be defined as the rules of conduct recognized in respect to a particular class of human actions or a particular group or culture. Some think of ethics as being the collective moral principles of a group that guide the group's conduct or behavior. Ethics are not precisely measurable. So, for example, some professions, including doctors, have a code of ethics that they are bound to, which is enforced by a body that governs admission to practice that profession. If a doctor fails to respect human life, dignity, or even human rights, for example, the governing body may revoke the doctor's license to practice medicine. Or, for another example, lawyers are bound to ethical and professional conduct that prohibits them from misusing client funds, maintaining intimate relationships with clients, representing parties on both sides of a legal transaction, and not zealously advocating for their clients. Morals, on the other hand, are personal in nature. They are the principles or habits with respect to right or wrong conduct. Morals are a person's standard of behavior or beliefs that concern what is acceptable or not acceptable for them to do. Some consider morality to be a personal compass of what is right or wrong. Like ethics, morals are not precisely measurable. So, for example, a doctor may personally think that abortions are wrong for personal or even religious reasons, and they may refuse to conduct even lawful abortions on that ground. Law, on the other hand, is a combination of common law and statutory law that may also encompass some aspects of ethics and morals. Law prescribes only a minimum of ethical, moral activity. For example, in the context of business, law does not provide purpose or goals that aid businesses to meet excellent service to customers, clients, or patients. But what law does do is provide for the minimum conduct that a business must comply with in order to operate. For another example, the law requires that doctors uphold a standard and duty of care owed to their patients. Doctors must provide the degree of care and skill of the average healthcare professional who practices that specialty, taking into account medical knowledge available to the doctor. If a doctor fails to uphold this standard and duty of care, they may be subject to malpractice lawsuits or even be imprisoned. Some laws or legal prohibitions come from or derive from ethics and morals that a society holds. Many policy issues that society faces are often resolved through law. In this regard, it is important to understand the moral and ethical perspectives that underlie the public policy debate. When the law leans on ethics of society or morals of individuals, the resultant law is said to be one of public policy. Public policies are principles, often unwritten, on what social laws are based. Public policy relies on the principle that injury to the public good is a basis for denying the legality of a specific conduct. So, for example, it is illegal to murder because society has deemed life of value. Or, it is illegal, in some places at least, to leave your dog's poo in your neighbor's yard. Or for another example, it is illegal to expel waste, especially hazardous waste, into the environment because society requires clean resources. Or we can look to the continuing controversies over stem cell research, medical use of marijuana, and even abortion. The differences in the law and public policy debates are based on differing moral and ethical values and perspectives. Businesses must also be ethical. Business ethics concerns what is right and good in a business setting. Certain moral and ethical issues inevitably arise from business practices, institutions, and during the decision-making process. Good ethics means good business, and that the business will be viewed more favorably by customers or other stakeholders. Markets and customers respond unfavorably to unethical business behavior. Goodwill is an intangible business asset that measures a business's reputation. A business's goodwill is in large part based on the actions it takes and on whether stakeholders perceive that conduct as favorable. The more ethical a business is, the more goodwill they will hold. The more goodwill that a business has, the more monetizable that reputation is, especially when used as leverage to raise the fair value of a business, maybe if it's being sold. Goodwill is usually specifically counted in the sale of a business as an asset that the buyer pays for. While it is difficult to place a monetary value on goodwill, an organization's reputation will generally call for a higher valuation in the final accounting before the sale. Okay, we've checked off our first objective. Now let's turn to the next. Here we turn to some ethical models of decision making for both individuals and for organizations. So, how can we evaluate ethical issues? What ethical approaches do we have to maybe resolve public policy debates? What ethical theories apply to difficult choices, not only in life, but also in business? Good business means good ethics, but how do they come to make sound ethical decisions, even when confronted with such incentive to maximize profits? Well, to answer these questions, businesses and individuals may look to ethical perspectives to guide them to an appropriate decision or course of action when faced with ethical dilemmas. There are a number of ways at looking at ethical issues. Let's talk about a few. Our first ethical perspective to apply to ethical dilemmas is utilitarianism. Under utilitarianism, moral actions are those that produce the greatest net pleasure compared with the net gain. Think of it as being, insert soundbite, it's the pleasure principle. Yeah, I know, I can't sing. Next slide. Utilitarianism is an ethical perspective that is highly aligned with economics, business, and management. Utilitarianism emphasizes results, not rules. Under this theory, action is good if it maximizes happiness or pleasure throughout society or an organization. This ethical perspective holds that an action is right if and only if the sum of the utilities produced by that action is greater than the sum of the utilities of any other possible act. There are two forms of utilitarianism: act utilitarianism and rule utilitarianism. Under act utilitarianism, each separate act must be assessed according to whether it maximizes pleasure or pain. So it asks, which action among various options will deliver the greatest good to society? Action is right if and only if it results in as much good as any available alternative. Utility in this regard means that the act or fact produces benefit, advantage, pleasure, good, or happiness, or it means that the act or fact prevents the happening of mischief, pain, evil, or unhappiness. Critics of act utilitarianism say that it is too difficult to quantify or measure what is good, and they also say that this perspective ignores other morally relevant considerations like human rights, justice, and the distribution of the good. Jeremy Bentham's famous saying illustrates act utilitarianism well: the greatest happiness of the greatest number. That is the measure of right and wrong. Under rule utilitarianism, the focus is on what rule or principle, if followed regularly, will create the greatest good. Rule utilitarianism supports rules that, on the balance, produces the greatest good. This perspective assesses the consequences of following a particular set of rules. It asks whether there is justification in harming a small number of people in order to save a larger number of people. Putting it all together, under rule utilitarianism, an act is right if and only if it is required by a rule that is itself a member of a set of rules whose acceptance will lead to a greater utility for society rather than any other available alternative. Or otherwise stated, an act is right if it conforms to a rule of conduct that has been validated by the principle of utility. Utilitarianism not only applies to conduct, but it also applies to legislation. When applied to creating laws, legislators may ask whether utility of a law or policy, meaning its usefulness, is measured by its tendency to promote the good, meaning to prevent harm. You know what? You've probably seen an example of utilitarianism in some of your other classes when you've discussed maybe the cost-benefit analysis. The cost-benefit analysis is used by businesses to quantify in monetary terms the benefits and costs of alternative courses of action or conduct. Businesses seek the great economic efficiency, according to the underlying notion that given two or more potential acts that they could possibly take, that the act that achieves the greatest output at the least cost promotes the greatest marginal happiness over the less efficient act, all things being equal. A frequent utilitarianism mistake in business is assuming that the greatest good for the company is the same thing as the greatest good for all. The mistake can be found in businesses looking at situations subjectively or with only the company's interests in mind. An example of this could be a company who has a product. That product has a defect. That defect detrimentally affects consumers, but the company does not alert the consumers or the public of the defect because they do not want to lose money in the long run. Not only would this mistake have legal consequences, but it would also have negative effects on goodwill. So thinking about this pleasure principle, how does it apply to individuals? Well, we see it frequently enough if you've ever frequented a donut shop or if you have ever considered whether to eat a dozen delicious donuts at the same time. If you only look to the short-term pleasure of how good the donuts taste, ignoring the long-term benefits of not eating the donuts, then we also make the classic utilitarianism mistake. Overall, the utilitarianism ethical perspective reflects an interest-based thinking or approach to ethical dilemmas. Interest-based thinking concerns human well-being, the common good, and the cost and benefits of a decision. Interest-based thinking considers a number of things like whether the course of action furthers true human well-being, or does it do so in the long term or in the short term? Or does a proposed course of action minimize harm to people affected, meaning the costs in relation to the benefits? Okay, on to our second ethical perspective. This one is deontology. Deontology focuses in on duty. In fact, deon is the Greek word for duty or obligation. This one is a little bit different than utilitarianism. Deontology addresses the practical problems of utilitarianism by holding that certain principles are right or wrong regardless of any pleasure or pain calculations. Utilitarianism, on the other hand, holds that morality is about good outcomes, or you could say that under utilitarianism, the end justifies the means. Deontology, on the other hand, does not hold that. Rather, deontology holds that morality is about good rules and duty. Under deontology, the ends do not justify the means. Here, you put your duty first, you act rationally, and you give moral weight to the inherent equality of all human beings. Immanuel Kant, a famous deontologist, presents his writings in the categorical imperative. The categorical imperative holds that for an action to be moral, it must meet two requirements. First, it must potentially be a universal law that could be applied consistently, and second, the action must respect the autonomy and rationality of all human beings and not just treat them as expedient. For the first part, about the universal law, we often refer to that one as universality. Universality is a basic principle of equality. That means that we should be able to universalize any particular law or action to determine whether it is ethical. For some rule or action to be universal, it has to meet two more requirements. First, it must be consistent. That means that it has to be capable of being consistently applied to all parties. Second, it has to be reversible. Reversible means that we have to be empathetic and be able to put ourselves in the other party's shoes. So for example, let's illustrate consistency. Question: have you ever lied before? I'm sure the answer is yes. We all have lied before, so don't be shy. Another question: have you ever considered misrepresenting yourself on a resume for a job? It's okay if you say yes. You and I are the only ones here. So to yourself in that scenario, you would probably say, when I have the job, I can prove that I was perfect for it. Nobody's gonna get hurt, and either way, the employer gets a great employee like me, and I will get a job. We both will be better off as a result. But what would Immanuel Kant say to that? Well, he would first say that your chosen course of action should be a universal one. Can that conduct be universalized? Can lying be good for all persons at all times? The answer is no. It cannot be universalized because it lacks consistency. The action of lying or misrepresenting oneself depends on the preexistence of honesty. So if you are willing to tell a lie, then you must also be willing to say that lying as a general universal phenomenon is acceptable. But what would happen if everybody consistently lied? If everyone consistently lied, then there would be no point to lying because no one would believe anyone else anyway. It is only because honesty works well for society as a whole and is generally practiced that lying ever becomes possible. So for these reasons, lying cannot be universalized because lying depends on the preexistence of honesty. As for the second part of universality, talking about reversibility, this one takes into account another person's perspective. Think about the golden rule: do unto others as you would have them do unto you. That emphasizes the reversibility concept. So if you try to make a decision as though you were in an opposing position, or as though you didn't know what position you would have after the decision, then that decision will be more likely to be made impartially and fair to all that are concerned. So back to the example with the lying and misrepresenting yourself on a resume. Reversibility would require that you consider the employer's perspective and the perspective of another well-qualified applicant who could lose the job because you lied on your resume. If the consequences are not appealing to all parties, then the action is probably not ethical. But you probably already knew that. Deontology reflects a duty-based thinking. It concerns promises, friendships, loyalty, community, and most of all, duty. It considers whether a proposed action or policy or even a law values the community and at what level. It also considers whether the action or policy or law remain true to promises made. You've probably seen some duty-based thinking recently in the debates over patriotism of NFL players, or even the patriotism of corporations when they move their headquarters offshore to avoid taxes. Next, we turn to social justice theory and social contract theory. These theories assert that certain obligations arise from the social nature of human beings. Each, in similar respects, focus on each person's individual obligations to other members of society, and they also focus on individual rights and obligations within society. Under social justice theory, the primary concern is distributive justice. Social justice theory, or distributive justice theory, stresses the equality of opportunity rather than the equality of results. Distributive justice considers how goods can fairly be distributed among a group of people. Marxist thought emphasizes that all members of society should be given goods, opportunities, and even economic equality according to their needs. So this type of thought would hold that there is a redistribution of wealth that would require a governing power to decide who gets what and when and how. Social justice in its purest form sounds like the opposite of capitalism. Capitalist thought takes a different approach. Capitalism rejects any giving that is not voluntary. Even more, some economists reject the notion that a corporation has a duty to meet unmet needs in society, holding that governments should play that role instead. In fact, social justice in its purest form, when used in a society or in a government, may look kind of like communism. Yet, even in societies like ours, we have social justice aspects of it as well. You've seen social justice theory in action all around you and probably every day, every time you get on the highway, every time you see assistance given to a natural disaster-stricken area, if you've ever received public education, or if you've ever been to a public park. Have you ever paid Social Security taxes or know someone who receives Social Security? Or what about Medicare? Those are all remnants of social justice theory. Social contract theory is similar to social justice, even though they maintain their differences. This theory holds that people live together in society in accordance with an agreement that establishes moral and political rules of behavior. So, social contract theory is an argument that is in favor of social responsibility. Some people believe that if we live according to this social contract, then we can live morally by our own choice and not because a divine being requires it. This theory is dynamic and it allows for structural and organic changes. Social contracts can be explicit, like laws or even the United States Constitution. Our Constitution is an example of part of America's social contract. It sets out what the government can and cannot do. People who choose to live in America agree to be governed by the moral and political obligations outlined in the Constitution's social contract. The social contract does not have to be explicit, though. It can also be implicit, like rules for classroom decorum, or raising one's hand when they have a question or want to speak for an instance. There are a few notable social contract theorists, including Thomas Hobbes, John Locke, and Jean-Jacques Rousseau. Hobbes was of the opinion that since a contract is the transfer of right, that in the state of nature, everyone has a right to everything, and there are no limits to the right of natural liberty. He pretty much thought that social contract is the agreement by which individuals mutually transfer their natural rights. So it's kind of like saying, I give up my natural right to you if you give up your natural right to me. That's really a quid pro quo. This for that. In that example, you just replace a natural right with a limited right. So for example, on an individual level, consider 9/11. The United States citizens agreed to abridge some of our fundamental and constitutional rights to privacy in order to fight terrorism when we passed the Patriot Act. Or for another example, on the corporation level, the social contract between the corporation and society would be the corporation receiving the right to operate their business in exchange for a perpetual duration and limited liability when they comply with the organizational requirements of a state. As you can see, United States positive law comes from whatever social contract exists in society. Just as the laws in a society can and do change over time, so will the social contract change and evolve over time. That's why the theory is dynamic. In all, social contract and social justice theories, respectively, they reflect a rights-based thinking. The focus is on fairness, impartiality, liberty, and human dignity. When applying rights-based thinking to resolve ethical dilemmas, we consider whether a proposed action or policy takes fairness seriously, whether it takes basic liberties seriously, and whether there are other basic rights that are affirmed or threatened by the proposed course of action. Other illustrations of rights-based thinking includes debates about diversity in the workforce, including gender and race, rights of employees not to be discriminated against on the basis of religion, rights of citizens against cigarette advertisements to minors. Those are often rooted in rights-based thinking. Or what about lawsuits against McDonald's for promoting obesity? Some think that the limits of rights-based thinking are kind of being reached there. Some of them claim that individuals have to take responsibility for their own choices and they do not have a rights claim against corporations. But reasonable minds can differ. Okay, for our last major ethical perspective, we have virtue theory. Virtue theory emphasizes the value of virtuous qualities rather than formal rules or results. Here, the goal of human existence is the active, rational search for excellence, which requires personal virtues of honesty, truthfulness, courage, temperance, generosity, and high mindfulness. Virtue theory rejects wealth, it rejects pleasure, and it rejects fame. Instead, it embraces reason as the distinguishing feature of humans as opposed to other species. Think of it like this. Under virtue theory, the use of reason leads to excellence and ethics. Therefore, true happiness is the rational pursuit of personal excellence or virtue. In virtue theory, Aristotle named 14 virtues. Courage, particularly in battle, temperance, or moderation in eating and drinking, liberality, or spending money well, magnificence, or living well, pride, or taking pleasure in accomplishments and stature, high mindfulness, or concern for the noble rather than the petty. There was an unnamed virtue, which is halfway between ambition and a total lack of effort. Then we have gentleness, or concern for others, truthfulness, wit, or pleasure in group discussions, friendliness, or pleasure in personal conduct, modesty, pleasure in personal conduct, righteous indignation, which means getting angry at the right things and in the right amounts. And then lastly, our last virtue is justice. From a modern perspective, some of these virtues seem kind of old-fashioned or maybe even a little bit weird. Magnificence, for example. How commonly do we speak of that? Probably never. As you may already notice, there are some issues that emerge from virtue theory. Couple of questions. Like first, how do we know what is a virtue these days? Or second, how useful is a list of agreed upon virtues anyway? And third, what do virtues have to do with companies, particularly large ones where various groups and individuals may have little or no contact with other parts of the organization? Well, Michael Josephson attempts to answer those first two questions by developing a core values list that just about everyone in American society can agree is kind of important to define what a virtue is. These values include trustworthiness, respect, responsibility, fairness, caring, and citizenship. Trustworthiness under his model means being honest and demonstrating integrity, being loyal, and keeping promises. Respect means respecting others, being courteous, polite, appreciative, and accepting differences among people. It also means respecting others' right to make decisions about their own lives. And it means not abusing, demeaning, mistreating, manipulating, exploiting, or taking advantage of others. From Michael Josephson's perspective, responsibility means being accountable for one's actions, being reliable, and pursuing excellence. Fairness means treating others fairly, being open-minded, considering others, even if they have opposing viewpoints, being consistent, and using appropriate considerations. In this model, caring means showing that you care about others through your kindness, caring, sharing, compassion, and empathy. It means treating others the way you want to be treated and not being selfish, mean, cruel, or insensitive to others' feelings. And lastly, citizenship. This means playing by the rules, whether they be the rules of society, community, or even within an organization. Citizenship means being a productive citizen that maybe pays their taxes, or is charitable, or is helpful to the community and protective of our shared environment. Under this model, a virtuous person, maybe even a business, is one that is trustworthy, respected, fair, caring, and observes citizenship. Okay, so let's take it a step further. Having a step-by-step basis to analyze difficult moral dilemmas is pretty useful. Josephson takes those core values that we just discussed and he employs them in an ethical decision-making model to help people and businesses make ethical decisions. The first step to any ethical dilemma is to recognize that there is an ethical dilemma or decision that must be made. The next step is to ask as many questions as possible to determine all of the background information of the dilemma. In order to do that, you have to identify the stakeholders. You may be asking yourself, who are these stakeholders? Well, on a business or an individual level, stakeholders are those who may be impacted by a particular decision. On the business level, stakeholders are those entities that the business may even owe a duty to. Stakeholders even include those who have an interest in the business's affairs. Stakeholders include the business's employees, the suppliers, the shareholders, the managers, the customers, the community, and anyone who most would agree is significantly affected by the decision of another moral agent. One of the types of stakeholders are called shareholders. Shareholders are owners of a corporation. Owners of a corporation can be natural persons like you and me, or they can be other legal entities like other businesses. Shareholders elect a board of directors of a corporation. The board of directors have legally prescribed duties, also called fiduciary duties, owed to shareholders. Directors hire officers that manage the corporation. They also have legally prescribed duties too. This is the legal organization of the corporation, generally. Okay, so after identifying the various stakeholders, we must also identify several likely or reasonable decisions that could be made. After that, we have to then consider which stakeholders will gain or lose with each decision. And then, lastly, we have to determine which decision satisfies the greatest number of core values, those values that we listed before. So after we go through all of those steps, if there is no decision that satisfies the greatest number of core values, then we are going to try to determine which decision delivers the greatest good to the various stakeholders and go with that decision. In all, virtue theories provide us with virtue-based thinking or ethical analyses. Virtue-based thinking is primarily concerned with responsibility, character, integrity, courage, and culture. It considers things like whether a proposed action or policy supports integrity and/or developed character. It also takes into account whether a proposed action or policy strengthens virtues like courage, prudence, truthfulness, and so on. In the world of business administration, the language of virtue is often heard in executive hiring situations, as well as in management development training. Okay, so we've checked off our second and third of our objectives so far. Let's turn to the next one. What are the differences between shareholder and stakeholder models of ethical corporate governance? Because corporations are not persons, but rather they are artificial entities created by the state, whether they can or should be morally accountable is difficult to determine. Though clearly, individuals within corporations can be held morally responsible, the corporate entity itself presents unique problems. Commentators are divided on the issue. Some of them insist that only people can engage in behavior that can be judged in moral terms. Opponents of this view concede that corporations are not people in any literal sense, but they still insist that the attributes of responsibility inherent in corporations are sufficient to justify judging corporate behavior from a moral perspective. So far, we've already talked generally about the legal organization of a corporation. We'll talk more about how other business entities are organized later on in the course. For now, we should note that the corporate structure lends itself to what we call the agency problem. In order to have this agency problem, there must first be an agency relationship. We'll talk about agency law and the agency relationship later on in the course as well. Until then, we can generally define agency as when an agent has the authority to act on behalf of and in the interests of someone else, called a principal. Here I have abbreviated agent with the letter A and principal with the letters PR. Directors and officers of a corporation are agents of the corporation, and that would mean that the corporation is their principal. The agency problem illustrates how directors and officers may not align their interests with that of the corporation and its owners. Ideally, owners and other top management should completely align their own interests with those of the shareholders so that they can meet the needs of the corporation and not violate those legally imposed fiduciary duties. A fiduciary duty is when someone owes a duty to someone else, and the person with the duty must act in a way that will benefit that other person, usually financially. Here I have abbreviated fiduciary duty with FD. Anywho, the person who has the fiduciary duty is called a fiduciary, and the person to whom the duty is owed is called the principal or beneficiary. If the fiduciary breaches their fiduciary duties, then they have to make up for their ill-gotten profits. Usually, beneficiaries will be entitled to damages. So in all, directors and officers of corporations, while they are fulfilling their managerial responsibilities, they have these fiduciary duties and they are the agents of the corporation. Primarily, they have duties of care and loyalty and of good faith. We'll talk about those a little bit more later on in the course. But the part about the duty of loyalty means that directors and officers working in their official capacities as corporate fiduciaries have to act without personal economic conflict. Corporate officers and directors cannot use their position of trust and confidence with the corporation to further their private individual interests, maybe by taking opportunities that would have otherwise been available to the organization or by self-dealing. So the agency problem is essentially a conflict of interest that is inherent in the relationship between one party, maybe the agent of a business, like those officers or directors, who are expected to act in the best interests of the business and shareholders. If a director or officer instead acts in their own self-interests, or if they act not in the interests of the corporation, then we have this agency problem. In all, the decisions and conduct of directors and officers must be ethical, especially in light to their agency to the corporation. Now that we know something about shareholders, let's turn to an ethical or governance theory called shareholder primacy. Shareholder primacy is a theory in corporate governance that holds that shareholder interests should be assigned first priority relative to all other corporate stakeholders. Essentially, it is a theory of corporate governance that focuses on maximizing the value of shareholders before considering the interests of the other corporate stakeholders. Advocates of the shareholder theory stress that corporations should focus on wealth maximization. A shareholder primacy approach often gives shareholders power to intercede directly and frequently in corporate decision-making. Traditionally, this theory was used by courts to resolve disputes among minority and majority shareholders, but over time, this theory evolved into the modern doctrine of minority shareholder oppression. This theory has been criticized as being opposite to corporate social responsibility obligations because it focuses a little bit too much on maximizing shareholder profits, and it does not account for the effects of business decisions on various stakeholders. A competing theory to that of shareholder theory is called stakeholder theory. Stakeholder theory is a derivative of the social contract theory. So one could say implicitly that there is a social contract between the corporation and all of the stakeholders. This social contract stems from a state granting a business perpetual duration and granting limited liability to other business forms and granting consent to the business to operate within its borders. Of course, in exchange for, this is the quid pro quo part, in exchange for the benefits of having increased business in the state. States allow businesses to practice their business by requiring them to register with the state, submitting specific forms, and following other formality requirements. In return, businesses are bound by the state's laws and regulations, which are their promises to the various stakeholders. If the state grants limited liability, then the corporation has the responsibility and right to encourage capital and innovation through legal means. And the corporation has a duty to act legally and, of course, ethically. Because there is a social contract, then the corporation has responsibilities to anyone affected by the corporate decision-making process. Proponents of stakeholder theory highlight the importance of corporations as employment resources, sources of higher quality products for consumers, and for social responsibility improvements within the general community. Under this theory, corporations and other business organizations must pay attention to not only the monetary bottom line, but also their overall effect on the community in order to be ethical and act ethically. So, a socially responsible and ethical corporation is likely to consider the impact of their decisions on all stakeholders, not just shareholders. Overall, taking into account our ethical perspectives and the organization of a corporation, we can have an overreaching philosophy to apply to businesses. Some effort has been made to integrate shareholder primacy theory and stakeholder theory, and that has resulted in another theory called conscious capitalism. Conscious capitalism embraces the idea that profit and prosperity must go hand in hand with social justice and environmental stewardship. It operates with a holistic or systems view, taking into account all stakeholders since they are connected and interdependent. You can think of conscious capitalism as being when businesses are woke. Woke businesses don't have to make trade-offs between stakeholder interests. Instead, they find creative ways to make all stakeholders win. The purpose of conscious capitalism is beyond merely maximizing profits. Instead, it delivers value to all stakeholders. Okay, we've checked the fourth objective off our list. Let's turn our attention to the last one. Why is it difficult to establish and maintain ethical corporate culture in a business organization? Ethical leadership is top-down. People in an organization tend to watch, observe, and even mimic what the top managers and officers say and do. Sometimes, if leadership is ethical, the practice of good ethics tends to trickle down to all other persons in the organization. And the opposite is also true. If leadership is not ethical, then that practice tends to trickle down to all other persons in the organization. Some managers may shift the blame to others or even act in their own self-interest in order to avoid accountability. Without strong leadership and a willingness to listen to constructive ethical criticism, managers will not have the necessary feedback to maintain a healthy organization. In light of that fact, many industries maintain ethics codes that are self-regulating, which means that they are imposed internally, or these industries are bound by laws that are meant to garner ethics. The best ethics codes are aspirational or having an ideal to be pursued, not legalistic or compliance-driven. In these circumstances, a corporate code of ethics is important as management makes them. Other ethics codes, on the other hand, are legalistic and compliance-driven. So, for example, there are the federal sentencing guidelines that were enacted in 1991 that were passed in order to correct the lenient treatment often given to white-collar or corporate criminals. While corporations cannot legally go to jail, they can pay civil and criminal penalties, and their managers can actually go to jail. Under the federal sentencing guidelines, companies can use the fact that they have a viable active code of ethics to mitigate criminal sentences that are imposed on them. So if a company can show that they have a means of rooting out the ethical wrongdoing within their company, then a judge would be allowed to consider that fact as a reason to lessen the fines the company will have to pay for violating an ethical law. That concludes our review of this chapter. As always, if you have any questions, please feel free to send me a message in Canvas or ask me after class.